Hi everyone, and welcome to another long-distance episode of Vienna Arbitration Talks. As you can see, I'm still in home office, and given the COVID-19 situation, I'm also conducting this interview from the comfort of our living room. But I do have a direct link today to the offices of Levy Kaufmann Kohler in Geneva, and there's a very special guest on the other end of the line, none other than Professor Gabrielle Kaufmann Kohler. Hi, Gabrielle.
Hi,
Welcome to Vienna Arbitration Talks.
nice to see you.
Nice to see you too. How have you been?
Fine, fine, a little confined like everyone else in this world under this pandemic situation, but fine, yeah.
I can imagine. How is Geneva? Is it getting warmer at least, so
It's
you
getting,
can go
no, no,
out a little bit?
the weather is beautiful, so in that sense it's nice. And one thing you can still do is go out for a walk, so
That's
take
true.
advantage of that, yeah.
That's true. Gabrielle, thank you so much for joining us. I will just introduce you shortly to our viewers. As you know, Gabrielle is partner at Levy Kaufmann Kohler. She's probably one of the most prominent arbitrators out there. She has acted in over 230 international arbitrations, and she is regularly ranked among the top 10 arbitrators worldwide. In 2016, she was named the most influential arbitrator in the world. So it really is an honor and a pleasure to have her with us today. Gabrielle is the immediate past president and now honorary president of the International Council for Commercial Arbitration, ICA. She is the past president and now honorary president of the Swiss Arbitration Association, and she has been a member of the ICC court, the LCIA court, and the board of the AAA. Gabrielle is also an expert on the Swiss delegation in Working Group 3 of UNCITRAL, and previously, when UNCITRAL was working on transparency in investment arbitration, in Working Group 2. In this regard, I just want to make this usual clarification that Gabrielle will be talking to us in her own capacity and in her own name, of course, today. So, Gabrielle, you have said you feel a little bit confined. How are you spending these strange times? I would imagine you were traveling a lot before the pandemics. Do you miss this traveling part of
Yeah,
being an
the
arbitrator?
travel stopped abruptly, like for everyone in the arbitration community and elsewhere. I must admit that I miss the sense of escape that I had that I feel when I travel. I miss the thrill of being elsewhere, of meeting other people. So yes, I miss the traveling. At the same time, we're very privileged in this crisis. We can work. We have moved online all our activities. So I don't think we can complain if you compare with other people who have lost their
Exactly.
jobs, have may have lost their business, have lost dear ones. So I don't think we can complain, and I would certainly not complain. Yeah.
How about the hearings? You have mentioned we have moved online. So I've seen that you've been quite busy with a number of awards in your cases recently. I can imagine you have also done a couple of hearings online. So how have those been? What's your experience in this?
Well, my experience is quite good in respect of hearings. Of course, it's not the same pleasure like meeting people in a room and having breaks and lunches and dinners. But in terms of functionality, online hearings are very well work very well right now. The logistics in terms, you have to have, everyone needs good connections, you have to have tests. One difficulty sometimes is time zones, because it reduces the available time each day, but that has its advantages too. You have shorter hearing days, you have more time to prepare for the next day, and so that is not the difficulty either, if you know how to manage it. I would even say that this is a lesson I will remember from the pandemic time. We will continue certainly to have a good number of hearings online, and well, it gives us more flexibility in managing the proceedings, in the sense that you can have several shorter hearings, you can split the hearings, you can bifurcate specific issues, simply because it's much easier to convene hearings and doesn't involve the cost that physical hearings would involve. So that is something that needs to be further explored. How can we make the dispute settlement more efficient by using online hearings in different ways than we have done with physical hearings?
So we can also do these things, I guess, after the pandemics. We will be able to change the way we basically change the way we manage the proceedings, right? I mean, as you've said, it's not really practical to bring all these people 5 times to a certain place, or 10 times or whatever, whereas organizing an online hearing is not that difficult. And honestly, I see maybe fewer logistical challenges in organizing it online than organizing it in person, right? I mean, I don't know. What is your opinion?
As well, in
Of course.
absolutely, you're right. And then there's another concern. We have been traveling too much, I think, if you look just at the protection of the planet. And
Exactly.
this is a good warning for the community that we should act more responsibly. And I will take this very seriously, yes.
Exactly. I wanted to ask you, since I guess you also do a lot of online lecturing these days. You're a visiting professor at Georgetown, at the National University of Singapore, at Tsinghua in Beijing, and at Sciences Po in Paris. So while I was clearing my desk today to make space for all these cameras, I came across this pen drive over here. I don't know if you can read it. It has materials on it from the MIDS, the Geneva LLM in International Dispute Settlements. So, so Gabrielle, since you created the MIDS, it has grown to become one of the most renowned and sought after dispute resolution LLMs in the world. So can you tell us, how did you come up with the idea? What was behind this?
Yeah, it's a long time ago. The MIDS is now, I think, in its 13th year, and the idea came up about 15, 20 years ago. I just saw the dispute settlement world changing. It seemed to me that there were more disputes, and there were more and more complex disputes, and specialists were needed to handle these disputes, and there was not much specialist education. There was some, but not much. And so the idea came up naturally with some colleagues to set up a program that would be devoted to international dispute settlement, not only arbitration, commercial arbitration, investment arbitration, sports arbitration, but other types of international disputes, including state-to-state, trade disputes, interstate arbitration, law of the sea disputes, and the like. Because, I mean, the dispute settlement techniques are always the same. You apply them to different types of disputes, but the techniques that you can learn are always the same, and the legal issues often, in terms of procedure, are the same or are similar.
Mm-hmm. I think it has worked quite well. I have met a lot of very bright alumni from the program. So congratulations on this.
Thank you.
If we're talking about Geneva already, we can move to your role and with the Swiss delegation of to the UNCITRAL Working Group 3. I mentioned before already that's currently working on the reform of investor-state dispute settlement, or ISDS. And ISDS has always been a rather controversial topic. These proposals for reform are basically changing it substantially. So what has been the arbitrations community's reaction to these discussions?
Well, the first reactions of many was pushback. I think the calls for reform were perceived like an attack against the way the arbitration community was doing its job. And that was a wrong perception, because the calls for reform were just a reflection of a changing world. There had been a shift of economic and political power from the global north to the global south. And then that shift coincided with a recognition in developed economies that investment arbitration was not a one-way street. It could turn against them as well. And
Right.
in addition, at the same time, we have seen the return of the state after an era of deregulation was in the context of the financial crisis of 2008. So all this put together, to me, explains easily why the criticism came up and why it came up at that time. But since I think the arbitration community's reaction has become much more constructive, it is engaging in the reform, it is participating quite intensely in the working group, 3 sessions so the arbitration community has understood by now that this is something that needs to be taken seriously and also needs its contribution to come to good solutions.
That's very good to hear. I was wondering what we, the arbitration lawyers, can expect from this reform. How will our business change?
I don't think it will change fundamentally. We will see probably higher expectations and requirements imposed on arbitrators in terms of independence, impartiality, and mainly disclosures. We might see more institutional appointments. Hopefully, we would also see more diversity, more transparent proceedings as well. We may also see, if you think of the substantive protections, investment protection standards, and we already see this in more recent treaties, maybe a narrower scope of protection, more specific provisions in terms of the scope of the protection.
So there would be room for harmonization of these standards, or maybe even.
There may be, yes, because absolutely, as the states adopt new provisions, there's of course a cross-fertilization from one treaty to the other that occurs. Yes, yeah. We will also see, maybe it's a little early to say, but likely for certain states or certain treaties, an appellate mechanism being superposed on the existing system. And we might see as well a multilateral investment court for certain treaties or for certain states.
So, Gabriel, that's exactly what I wanted to talk to you today. This multilateral investment court. You have created the Academic Forum on ISDS, which is a platform for academics active in the field of ISDS to exchange views and explore ideas for the reform. And the forum has been particularly helpful in the ongoing discussions in the working group. And it has addressed this potential reform possibility, a standing multilateral investment court. Do we know yet what such a multilateral court could look like, and what have been the proposals so far?
Yes, let me first say that I'm very happy that the academic forum idea materialized as it has, and that the academic forum members have been very active in providing expertise on rather complex issues to the state delegations. The states will make the policy choices, but if they have this input from the academic community, this should facilitate the choices. Now the court, there's been already a few discussions on the court in the working group. Of course, its contours are not yet clear, but what one can see is that it would rather be a selective representation court, not a full representation. That means not a one state, one judge court. And there should be a selection process that will allow to have judges on the court or adjudicators who are independent, have the required expertise, and there should be a composition that is diverse. Now, to allow that, you would need a broad-based consultation at the beginning to generate good applications, as many good applications as possible, and a very transparent process. Then, because there will hopefully be many good applications, you need to have a selection committee or a screening body that will vet the candidates and then make recommendations to the state, and that committee should make sure that the requirements are met and also ensure that the quality of the candidates are up to standard.
Who can then make, who can they make this final decision?
The final decisions, I think, will be made by the states that are party to the constitutive treaty of the state.
So there would be a conference of the states regularly, or...
Yes, but to avoid that, there are political designations in the bad sense of the term. The screening process should be very rigorous, and there are different ways of organizing this process, different ways of appointing the people who will proceed to the screening. But that is a very important part for the success of the court, in my view. And then you will also need to protect the judges from political interference. That is a difficulty we don't have in the current system with private individuals who are appointed for one proceeding. It will be more difficult for judges, but there are ways of doing it by giving them security for tenure, of tenures, financial security, possibly long terms without renewal, because that seems to be a more protective solution than shorter terms that can be renewed. And
when they would have to think about how they are deciding in order to get their terms renewed, right?
Exactly. Yes.
Yeah, you have mentioned criticisms of the current ISDS system, and I was wondering, maybe we could go through a couple of these criticisms and see how this investment court, a standing body, could address this problem. So maybe if we start with the criticism of lack of consistency and coherence of decisions. And then we can also maybe continue with the potential incorrectness of these decisions. These criticisms have been expressed, and we know that tribunals, the arbitral tribunals that we have right now, they're not really bound by precedent. There have been cases where under the same treaty, even the same state measure, tribunals have reached different outcomes in their decisions. So how could a standing court address this problem?
The lack of consistency is really inbuilt in the current system, where you have one-time tribunals and no hierarchy. And so the fact that you would have a court should bring consistency, because the court will say what the law is, and then will consistently apply its own precedent. At least that's what it should do. So the court should help consistency. Of course, the question, it will then be over which treaties does this court have jurisdiction, and there could be still other treaties that are not subject to the court system, and therefore there might be some inconsistency. But I believe that if there is a court and it's considered sufficiently representative, it will also have some persuasive authority for other tribunals that may rule over other treaties. I'm not, of course, ignoring that treaties have some differences, and that may also justify different conclusions.
Of course. So what I was wondering is, can we say that the standing tribunal is more likely to render decisions that are correct than an ad hoc constituted tribunal? Like if we go to incorrectness, and what is a correct decision in the first place?
Yeah, that's a difficult question. And when I first heard about this criticism, I thought, as an arbitrator, I do know that reasonable minds can legitimately differ about what the correct outcome is of a case. And so it is a more difficult concept, I would say, than consistency. Consistency is a relative concept. It implies a comparison between two decisions. Correctness is an absolute concept. That means it's either right or wrong. It's either black or white. So what is a correct decision? Having said that, is probably best defined by a decision that identifies the applicable law, applies the law, and interprets the law properly. Now, of course, a court could get it consistently wrong. It's not because you're the Supreme Court of a state, for instance, that you don't give an incorrect decision.
Exactly. Then you would have consistently incorrect decisions,
Yeah.
right?
Yeah. In theory, perfectly possible. At the same time, I say that there is some interaction between the two, and some relation. I think that faced with inconsistent prior decisions, a court will have to choose what legal solutions it wants to give, and it will ponder the different solutions that are already there, and hopefully will take the better one, which should also be the more correct one. So that, in that sense, there is some link between the two, but they're distinct concepts.
What kind of issues would this kind of an appellate body or basically the second instance consider? What could be these grounds for appeal?
The grounds for appeal would necessarily be an error of law, because otherwise it could not fix the consistency issue. The debate is now whether it should also cover errors of fact. My personal opinion is that opening errors of fact may open a full de novo review in second instance, which was all the consequences in terms of costs and delay that would be negative consequences. So there is some, I would be somewhat reluctant about errors of fact, and I don't think they need to be covered by the appeal to deal with consistency correctness. At the same time, I also see a strong demand by states to cover issues of fact, and mainly the states now focus on manifest errors of fact.
Yeah, maybe have some water. I will do the same.
Manifest errors of fact are, as I understand them, errors that are apparent on the basis of the record of the first instance, and so that would limit the scope of the inquiry at the second level.
I see. If we move to the next criticism, which is this lack of independence, impartiality, and neutrality of adjudicators. So some people have said arbitrators are biased, they want to get reappointed, they work for the investors. We have heard a lot of things. How could a multilateral investment court address this?
Well, if you look at these criticisms, most of them are linked to the appointment of the arbitrators by the parties. That is, for instance, repeat appointments. You just mentioned
Exactly.
it. It also linked to polarization of arbitrators, that is, in the sense of profiling arbitrators as either pro-state or pro-investor,
Investor.
and also to the fact that arbitrators have other activities. Double hatting, for instance, is a manifestation of these other activities, and through these other activities, they also, of course, develop all kinds of connections. So the criticism is essentially about these aspects that are all linked to the appointment by the parties. Obviously, the court would fix that in the sense that the disputing parties would not appoint the judges. They would be permanent, so they would have no other activities and they would have no other connections arising from these activities. And they would also not be either pro-state or pro-investors as a result of their appointment. Of course, the judges would be appointed by the contracting states to the court, and one of those contracting states would be the respondent in the specific dispute, and that is a concern and needs to be dealt with through the selection process and the other guarantees for judicial independence that I mentioned before. But that is a concern that needs to be identified and dealt with.
You have just mentioned that a lot of these criticisms stem from how we do arbitration right now, that the parties are the ones that appoint arbitrators. Has there been any concerns about the right of parties to appoint an arbitrator for the particular case if we go through with the investment court, the multilateral court?
Yes, there's of course there's a strong attachment to the right to appoint one's arbitrator. We know this for commercial arbitrations for many years, and we hear investors say so. And much to my surprise, we now hear states also wanting to continue to appoint their arbitrators. This was a recurrent theme 3 weeks ago in the last session of Working Group 3, and I was surprised by it because the states had been the ones bringing forward these concerns about the arbitrators, and if you analyze them correctly, you see that they are rooted in the party appointment. And so then how do you bring the two together, being for a party appointment and bringing up these criticisms? But that is a lesson. Things are not always rigorous in terms of analysis and not always consistent. You have to, in the reform works, you have to consider all these different points of view and try to get to a solution where that everybody can buy into. Yeah,
exactly. Speaking of this, let's move to our last criticism that we are addressing today, the lack of diversity. I think lack of diversity is unfortunately still a major issue, both in investment and commercial arbitration. And whereas we can't really fix it in commercial arbitration by creating an investment court, I guess in this kind of standing judges, standing body, this lack of diversity can maybe be addressed quite well. I read a study that found that women account for merely 11% of investor state arbitrators. And if we look at the 25 most influential investor state arbitrators, only 2 of them are women. And dear viewers, I'm very happy to say that we have one of them on the call today. There is still a substantial problem with equal representation, of course. When it comes to geographical diversity, the situation is not much better. 22 of those 25 arbitrators I've just mentioned are either from North America or Europe. So, Gabrielle, when you were the president of ICA, you contributed to its diversity and inclusion policy and the implementation plan. So, what would be your suggestions on what to consider when nominating the members of the standing body to ensure gender and geographical diversity?
So, if we take first gender diversity, I would be very interested, and I don't have these statistics, and I don't think they exist over time. How has it evolved? I could think that 30 years ago, the percentages were much lower, and then they have grown, and maybe in the last years they were higher. So that would be an interesting indication to see the evolution and documented with empirical data. But even from my observation, I see that gender diversity is progressing. One may think that it is progressing more slowly than we would wish, but it is progressing. You see it in institutional appointments. You see it less in party appointment, but you see it in the increase of institutional appointments in favor of women. And there is also a general awareness. I mean, the very fact that we discuss it now shows that there is an awareness in the community, and has been helped very much by initiatives such as the Pledge. And so I see this, the gender diversity progressing. Regional diversity is more problematic. We now speak about ISDS, of course. It is, you gave some stats. I've seen empirical data that say that 24% of all ISDS arbitrators are from Western regions, West standing for Europe and North America. And all others, 76%, no, did I say?
The other way around, right? The other way around.
Right. 24% from non-Western regions and 76 from Western regions. Now, when you contrast this with the number of times that non-Western states are respondents, you see that there is a severe imbalance, and that that's to me a serious issue in terms of just justice vis-a-vis underrepresented groups, and it's also a difficulty in respect to the acceptance of awards that are given against these states. So that needs to be improved. A standing body would help, because you can, in the constitutive treaty or other documents that constitute the court of the appellate mechanism, you could have either quota or at least targets of diversity, both gender and regional. Now, what is regional? Regional in ISDS probably is in good part a function of the level of development, and that needs to be taken into account, and that of course changes over time, so there should be a mechanism to be able to change the targets. And of course regional also stands for cultural, racial, religious diversity. So there's a number of parameters to be taken into account, but the main one I would say would be the level of development of the economies involved.
I very much hope that we fix this soon also in commercial arbitration, but in any case the investment court would be one way to consider this. And as you have said, we could ensure that these goals for diversity are also being considered by having a body that is screening candidates, right?
Absolutely, yes, yeah.
No, thank you so much, Gabrielle, for joining me today. I really appreciate that you've taken the time, and it's of course always a pleasure to talk to you. I hope we get to see each other soon in person at some point. Maybe we can invite you to Vienna for another interview, so that we can at least get you a proper Viennese coffee.
That would be
We can't offer you.
I like Vienna very much. And I thank you for having me and all of those who listened for having done so. Thank you.
Thank you so much, Gabrielle. Thank you. To you, dear viewers, thank you for very much for watching us today. We're already preparing some really exciting new interviews, so make sure to join us next time. In the meantime, I wish you all the best and greetings from Vienna. Stay safe.